reflects how much we all feel that this is a watershed moment in public funding for legal services in this country. Let's make no mistake about it. These cuts, the cuts that are proposed by Mr. Grayling at the moment, will change the British legal system forever. They are absolutely profound changes. Around the world, our system of justice is envied. Perhaps sometimes it's given too much credit, but it's envied. For anyone who has appeared in international courts in Strasbourg or wherever else, if you've ever talked to any of the international judges, they'll tell you that when lawyers from the UK turn up to argue cases, they're best pleased. And the reason for that is the quality of our lawyers and our legal system, and very much born and bred on publicly funded legal services. If you think of the amount of international litigation that is conducted in this country, it's conducted on the back of your reputation. The millions of pounds that is spent in this country on settling international disputes, it's there because of the service that you lawyers, publicly funded lawyers, have done over the years. It's all because of the reputation of the system. If you destroy that reputation, the savings from the cuts that are proposed is a small drop in the ocean to the amount of money that will be lost to the economy in this country. Robert's spoken about Mr. Grayling's interview in the Law Society Gazette yesterday. He admitted he had no evidence of a loss of confidence in the legal aid system in this country. He admitted that the MOJ had not looked at the Weatherby QC, this tendering business which is based on simply the cheapest available providers, nothing to do with quality. They'd not looked at whether it was either workable or whether indeed it worked out cheaper. And there's a major question mark over both of those questions. He hasn't looked at, he told the Law Society Gazette, the experience of other countries and how they organise their legal aid, publicly funded legal systems. He did, of course, assert that our system is one of the most expensive in the world. How does he know? The only research that he's quoted is an MOJ-funded academic paper, which he's misquoted from, and which doesn't look at like comparators. For example, if you have a system like in France, where you have investigative magistrates, you simply load your funding on a different part of the system. How does he know the comparative costs of the system in this country? He doesn't. As Robert's quoted, today we actually do have some evidence. We have evidence from this Comres poll that's been published. We know that 71% of people in this country think that cuts in legal aid provision will directly lead to major miscarriages of justice. We know that 2/3 of people say that legal aid is a price worth paying for a fair justice system and a fair society. And perhaps most importantly of all, we know that 68% of people in this country believe that the current level of spending, but 0.5% of government spending on legal aid, is a worthwhile expenditure on basic freedom. The current proposals, as Robert has said, will at a stroke wipe away 3/4 of solicitors' firms. That is not scaremongering, that is the word of Mr. Grayling himself. That's what these proposals are aimed at. It may be even worse than that. The bids will have to be made 17.5% less at least than the current levels of payments. Which firms, solicitors that you work with or are at, how many of you earn anywhere near that level of profit at the moment? If the government succeeds, their aim is to reduce the market to a number of major providers who will employ people at very low wages, unskilled people, and the level of legal provision will plummet. cheerful bargain basement service, and quite frankly, most of us will be out of work. The government want people like Serco and G4S, the people who run private prisons, the people that seem to be rather good at losing prisoners and failing to bring prisoners to court on a regular basis. They want them to make these bids. They'd like Tesco's and they'd like any Stobart haulage firm to enter the market. What do they know about proper legal provision? Will Tesco's and Eddie Stobart really want to represent Ian Huntley and Myra Hindley? Does it suit their brands to do so? Are they going to provide any decent service? Are they going to do it at the cost that the government thinks that they will? If the market shrinks and these big firms become the only providers, how long will it be before they go to the government with ever-increasing amounts of also, rather insidiously, require advocates to go to both the Magistrates' Court and the Crown Court for fees which are fixed regardless of whether clients plead guilty or have a trial. If a trial goes on for any length of time, the level of income that is being proposed for advocates in the Crown Court tapers off to £14 per day. That is well below the minimum wage. What is going on here? The government is trying to shrink justice, trying to make people, advise people against their professional requirements, and are trying to speed up the conveyor of justice and sacrifice justice. It's disastrous for legal services in this country. It's disastrous for people who are our clients, and it's disastrous for lawyers. It's not just career criminals who end up in the federal courts. Many others do too. The right of legal aid protects the rights of the guilty, as it does for everyone else. But it protects the liberty and the reputations of the innocent also. It's difficult to put a price on liberty and reputation. These proposals simply give us the cost, and the cost is miscarriages and increasing miscarriages of justice. The government is big on choice. If you look at policies to do with health and education, this government will go on and on and on about how we, the ordinary people, should be given choice. In legal services, the government say precisely the opposite. Mr. Grayling's proposals remove choice entirely from publicly funded legal services. A government flagship policy just jettisoned in the attempt to save money. Our clients are too stupid to make the choice, he told the Law Society Gazette yesterday. Only a few days ago he told a delegation of lawyers, however, that he was removing choice so he could guarantee work for the few remaining firms that remain in work when these proposals come in. Which is it, Mr. Grayling? Tell us the truth. He's removing choice, which removes specialism. You've heard from the first speaker today about her experience of her sons being involved in a case which requires lawyers with certain specialisms. If you remove choice, if you're arrested on suspicion of a fraud offence, do you really want a lawyer that specialises in sex offences or terrorism? Let me say something about costs also. There's no word in the consultation document, there's no word from Mr. Grayling about how much all of this will cost. He tells us it will save £220 million, but will it? What are the true costs of putting all this out to competitive tendering, to junk quality, and to try and get the lowest bids? What is the costs of that? Ask those in the health sector, because they know, because they've had price competitive tendering in the past. It's a very, very expensive business where consultants and compliance experts come in. Will it work? Well, will it simply reduce the process to the lowest bidder? Look at the recent similar exercise with interpreters, a disastrous exercise, as many of you will know, and an exercise where the government has reduced it to the lowest bidder and then realised that the lowest bidder can't provide even the minimum of services. Finally, before I wrap up, let me talk a bit about civil legal aid, because what we mustn't miss here is the attacks not just on criminal legal aid, but also on civil. We've already had 620,000 people taken out of civil legal aid for family, employment, immigration, prison law, with the cuts that came into force on the 1st of April. Now